Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Well, guys, good Monday afternoon, and disaster has struck in my house. My keyboard got covered in coffee, and now it's acting up. I may not be able to do this live, or I need to find another keyboard. Let me ask my son if he has an extra keyboard. Let me get him in here. Coffee spilt all on my keyboard, and this sucks. Hey, Matt, I need your help. I'm live. Yeah. Hey, everybody. And I spilled coffee all over the keyboard. You got an extra one I can borrow real quick? The keyboard's probably done. Probably broken completely. I don't know if I can salvage this. Is it mechanical or electrical? I don't know. You're the one that bought it for me. Why don't you look? Yeah, you can stop for a second and look. It is that Logitech really expensive one that we got. Ah, shit. Now I got to go buy a keyboard, guys. Oh my gosh, my keyboard is fried, and which means I'm trying to come up with stuff and I can't. Oh my gosh, y'all. I'm going to give it a minute and see. Nope, it's not working. I type it in and it gives me the comma. And it is not plugged in. Turn it off and do what? But I'm alive. I'm alive, guys. Okay, what we're going to do, I'm not going to type anything. We're just going to take this and go through it. Okay, so we are going to break down the newly released Massachusetts Supreme Judicial Court decision in Kelsey Fitzsimmons versus the Commonwealth. The case that is sits at the intersection, I guess, for the lack of a better word, of dangerous law, mental health, police response, and judicial discretion. The Commonwealth alleges that Fitzsimmons, a North Andover police officer, pointed a firearm at officers. Yes, sir. The longer you have power going to that, the worse it's going to get. I just turned it off. Okay. I have to wait a day or two. Can I? You can remove all the keys. I can't.
I'm not.
I don't know how to do this.
You can pull the keys off.
Oh, he wants me to pull all the keys off and then remember how they go.
Yeah, you can take a picture before you.
Oh my gosh, y'all. I'm going to have to do this and then do what, Matt? Oh my gosh, y'all. Duh. Well, I can use my iPad for some stuff, but anyway, she is accused of pointing a firearm at an officer, serving an abusive protection order, pulling the trigger, and attempting to rack around before being shot in the chest herself. So what we're going to do is, I have no keyboard, but I did have the document pulled up. So we're lucky I got the document pulled up. So we're going to read through this document. Oh my gosh, y'all. And I had another big live we're going to do. So I'm going to have to go to the store and buy me a cheap keyboard until I get this thing fixed. And it's going to suck a duck big time, y'all. Oh, this is going to be horrid. Okie dokie. So what we're going to do is, I'm going to see if I can embiggen this one more step. There we go. I can read that now. Yay, yes. Oh my gosh, y'all. This is disastrous. I stood up and my coffee spilt all over my keyboard. And my son is telling me now I need to remove every one of my keys. Now, I know the upper keys were not affected. I know certain keys were not affected. But other keys were. So I've got to pop all these keys off and try to salvage the keyboard. Well, it is a keyboard. It's a type of keyboard, y'all, that that you can clean it and take it apart. So I'm going to do that because I can see where the water hit what keys. The coffee hit the keys. Yeah, I know. So anyway, while we say hello and let some people pop on while I sit here and pop off all my keys, I'll try and get this thing to air out. Maybe I can salvage it. We'll see. Well, it's kind of cool that you can pop the keys off. I mean, it is a high-end keyboard, but I have had it for quite a few years, so maybe, I don't know what they cost now, but I just can't afford to do this again. Yeah, that didn't get wet. But this is what it looks like when you pop all the keys off. And yep, they're full of coffee, so I'm going to have to rinse them all off. I'm going to move them to the side. I'm going to let this thing dry out a little bit, so that'll be a good thing. And it's got a lot of dust buildup, so it'll be good to clean it. Hopefully I can salvage it. Y'all say a little prayer to the keyboard gods. Say a prayer to my keyboard gods and see if this is something that is salvageable. It would be nice if this thing survives the coffee. Give me some good vibes, y'all. Throw up some hearts if you're giving me some good vibes. You know, I'm surprised I hadn't done this sooner, in all honesty, but that's life. So we are going to dive into this. Fitzgerald. So the Superior Court originally released her with strict conditions: house arrest, GPS monitoring. They released her with alcohol monitoring, treatment requirements, and parental custody. Her claim is that SCRAM testing was physically impossible. That's where they test her due to gunshot-related injuries. So that's where they have you blow into a machine. And in that machine, they're testing for alcohol. Okay, to see if she was drinking at the time of the event. Now, she claims that it was impossible for her to do that particular test because she herself had been shot in the chest. And when you're shot in the chest, let me tell you, you're not going to be able to blow into one of those machines effectively. Now, they are claiming that this is an ADA law situation. Well, I don't believe it's an actual ADA law. I think it's more of a medical exemption more than an ADA law, because ADA defers to disability unless it's got a window in it that I'm not familiar with. But then again, I do know quite a bit about the ADA law. Now, I am not an ADA lawyer. I don't plan on being one. Thought about it, but don't plan on it. So, anyway, so that's where they're going with that. They did a hearing. The judge the legal question before the Supreme Justice Court is, did the hearing judge abuse her discretion when she revoked the release and ordered detainment under the GLC 276 at 58A? And did the single judge err in denying extraordinary relief under the GLC 211 at 3? So we're going to read through this document, and we're going to kind of see what it says. And now that I can't type, I'm screwed. Oh my gosh. Let's see if I can pop out chats in YouTube so I can see what y'all are saying without using my keyboard. Y'all pray to the keyboard gods, please. Pray, please pray. I cannot afford to lose this keyboard. I may have to go to Wally World and get a cheapy keyboard, which I don't want to do, which is not something I'm comfortable doing. I hate those cheapy keyboards. Oh, not what I needed to be spending money on today. That's for dang sure, y'all. All right. Let's see what's going on. Y'all, yeah, right. Like a true IT tech, take off all keys. I got it, but I will not be able to, guys. So everything I do is going to have to be verbal. June, I got that. I'm popping out my chat so I can see what the heck is going on with you guys. Let me get it stationed. What a wonderful way to start my day, y'all. Wonderful, wonderful way. Hello, good morning, Ari, or good afternoon. Hello, June and Angela. Hello, Karate Cat Mom. Hello, guys. Okay, we're going to go through this. This is a notice. All SIP opinions and orders are subject to the form. I can't read it like that. I'm going to have to make some adjustments here. Give me a minute, guys. Give me a minute. I'm going to have to do some adjusting to get this. I can follow you guys and do everything else. Come on, mouse. I don't need any problems today with anything else. I don't need problems on any other aspect of this day today. Okay, so I'm getting everything up and running in a way that I think I can manage. All right. All SIP opinions and orders are subject to formal revisions and are suppressed by the advance sheet of bound volumes and blah, 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 blah. All right, here we go. Pretrial detention, assault by means of dangerous weapons, Supreme Judicial Court, superintendent of inferior court. All righty. Here we go. The petitioner, Kelsey Simmons, appeals from the judgment of a single justice of this court denying her petition for extraordinary relief pursuant of G.L.C. 211, comma, whatever that symbol is, I'm going to call it at number 3, period. Here's the background. Yeah, ask you Santa for a miracle on this keyboard, because this keyboard was a very expensive keyboard. I got it when I had money. And I am hoping and praying that it is not fried. I'm going to turn it upside down in hopes of whatever is down will come out. Okay. Background. Fitzsimmons stands indicted in the Supreme Court of Essex County on the count of assault by means of a dangerous weapon in violation of cited, in connection with the incident in which the Commonwealth alleges that on June 30th of 25, Fitzsimmons, who was a North Andover police officer, was served by police with an abuse prevention order. Okay. Well, I can't. June, can you go? I can't do it. Well, let me do it this way. Maybe I can do it. Give me a second. In the state of Massachusetts, please give me a description of what a prevention in Massachusetts law. Please give me a description of abuse prevention order and when would it apply? Okay, we're going to go that route. A prevention order, also called a 209A order, is a restraining order or protective order, which is just another terminology designed to protect someone from abuse by a family or household member. All righty. It's just different wording. After deceiving officers about the location of firearm in her home, she drew a firearm, pointed it at one of the officers, and pulled the trigger. When the firearm did not discharge, oh, you mean to tell me she shot once and her own personal firearm did not discharge? What the hell? I'm going to try and get this a little bit better. I'm trying to get this a little bit in bigger. Give me a second. Yeah, it's not going to work. Not the way I want it to. Well, maybe if I do it this way. I'm working on making this a little bigger for everybody. Okay, that's about the best I can do. So not only did she pull a weapon on police officers, she also tried to discharge said firearm, and that said firearm did not discharge. Holy crap, that says a lot for you and your firearm. Wow. Fitzsimmons allegedly attempted to rack a round of ammunition, meaning there was not one in the chamber, and I need coffee and I'm out. The entire cup fell on my keyboard. During which time the officer twice yelled, "Kelsey, don't do it!" Or other words, effectively instructing Fitzsimmons to drop the firearm. The officer then shot Fitzsimmons in the chest. Fitzsimmons was originally charged in the district court with one count of armed assault with intent to bedroom in the violation of G period LPC period 265 at 18B, and 2 counts of assault by means of dangerous weapon in violation cited. Upon the motion of the Commonwealth, she was held on a dangerous grounds pursuant to cited. What is this? Yep, classic. It'll survive. This stuff happens to me all the time. Are you telling me that this is going to be okay? Because right now, I might as well wash all these keypads because they're covered in coffee. But right now, this is the condition of my keyboard. Smells heavily of coffee. I'm praying, Lord, please let it work. But now I gotta let it. I have to let it air out for a long time, overnight probably. Which means I am going to go to Walmart or somewhere and get me a cheap keyboard because I've got a big live we're going to do later today. So it will get done. Anyway, the petition for review, the Superior Court judge likewise found Fitzsimmons dangerous and ordered her detained. On August 25th of 2025, Fitzsimmons was indicted in the Superior Court. The grand jury declined to indict her on a charge of armed assault with an intent to bedroom, and instead, Fitzsimmons was indicted on a single charge of assault by means of dangerous weapon in violation cited. A conviction of that charge carries state prison sentence of no more than 5 years. As it had in district court, the Commonwealth moved for detention on the basis of dangerous pursuant to GL cited. The support of its request, the Commonwealth submitted a number of documents, including the police report detailing the June 30th shooting incident. As described in supra, as well as affidavit and witness statements concerning the indictment and the alleged events leading up to it. In one such statement, Fitzsimmons' former fiancee alleged that in a party on June 28th of 25, Fitzsimmons became intoxicated and violent, striking him multiple times and making self-harm statements and threatening statements concerning the couple's young child, all of which prompted the former fiancé to seek an abuse prevention order. Boy, it must have been a doozy for him to get it. He also allegedly warned the police that they served the abuse prevention order on Fitzsimmons. She would attempt to unalive the baby and the officers involved, and then herself. Another witness statement indicated that Fitzsimmons had struggled with mental health issues, aggression, and alcohol abuse, and she's a cop. The Commonwealth also submitted an affidavit that Fitzsimmons' former fiancé in support of the abuse prevention order, which echoed the above described representation. A further representation that Ms. Fitzsimmons had been sectioned in the recent past. Finally, the Commonwealth submitted an out-of-state criminal history record indicating that Fitzsimmons had been convicted in 2019 of the misdemeanor offense described in the document as intoxicated and disruptive. In contesting the Commonwealth's motion, Fitzsimmons relied on a letter from the doctor affiliated with the hospital where she had received treatment after the June 30th incident. The letter indicated that while she was initially held in pursuit of the cited, she no longer met the criteria for involuntary hospitalization and was appropriate for outpatient care. The record indicates the statement referred to an involuntary hospital for mental health treatment. See the cited. Authorized restraint and hospitalization of a person for limited period. Of failure to hospitalize the person would create the likelihood of serious harm or mental illness. Wow. Y'all. Yep, classic. Additionally, Fitzsimmons relied on the report of an expert psychologist who concluded that Fitzsimmons posed no credible risk of harm to herself or others, and that the risk of harm from returning her with her child was all but non-existent. So, in other words, they're saying after this catastrophic event, and she's shot in the chest, and she's gone through the healing procedure to a point, and was evaluated and said she's no harm to herself or others or her child. I'm not too sure I would agree with that. Would y'all? After hearing the August 28th, after a hearing on August 28th of 2025, the hearing judge determined that Fitzsimmons is too dangerous, and concluding that her release on personal recognizance would not reasonably assure her appearance at future court dates or would endanger the safety of other persons in the community. In other words, they're thinking she will either start harming other people, her child, her ex-husband, her ex-fiancé, and or herself. Nevertheless, pursuant to cited, the hearing judge found that Fitzsimmons could be released subject to conditions, meaning she can't be released on recognizance, meaning no supervision. She just promises to come back to court. No, she would have to be released under the care of a supervising agent, is what they're talking about. The hearing could be released subject to conditions reasonably assuring community safety, including and relevant here the following. This is what her conditions of release were. Fitzsimmons was to remain in the custody of her mother and stepfather residing in their home, meaning at all times, 24/7, 7 days a week, with the exception of going to the toilet in reasonable terms, they have to see her. I know. Been through this experience with somebody else I know. So if she's in her bedroom, somebody has to be in her bedroom. They have to have camera monitoring. It depends on the severity. It depends on the restraints put on probation by probation, but it can be that extreme. It can really be that extreme. The Fitzsimmons was to remain on 24/7 house arrest except for medical, court, and attorney visits, providing a 48-hour notice to the Department of Probation or probation here in advance of any such visit, unless side note, it was a medical situation. In my prime music, Ryan, in my personal opinion, the magistrate should not have released her under conditions to begin with. The crime and the history of the defendant are too dangerous, and I'm not disagreeing with you. Hey, June, do you see the conversation in Discord about this today? No, I did not see it. I don't know if June did. That's a problem. There's some of us who love to agree to disagree. Number 3, Fitzsimmons' location was to be monitored by Global Positioning System or GPS, and she was not to be released until GPS monitoring was in place, meaning it takes a couple of days, so she was not going to be able to be released and then get it on. They would have to put the ankle monitor on her there at the jail, and the system had to be set up and running at the time that she arrived in the home, which takes a couple of days to get set up. Fitzsimmons would abstain from alcohol and be subject to breath testing by secure continuous remote alcohol monitoring or SCRAM, and that Fitzsimmons was to follow a treatment plan and provide by 2 weeks specifically named doctor, so that she was supposed to have a breathalyzer that she would have to go at specific times, scheduled, and also they can go in there and say, hey, you got 2 minutes to get to that machine and start blowing. So it can be scheduled and non-scheduled, what I call pop-up testing of that, with that SCRAM. And on top of that, she had to be in a treatment plan, and she must have a doctor that it was specifically provided by 2 specifically named doctors. She had to have 2 doctors monitoring. Now, the hearing judge concluded that these were the least restrictive conditions necessary to assure Fitzsimmons' appearance and protect others. I'm not sure I agree with you on that. I do agree with you on the point that she was released. I believe that she should have been remained in custody either for evaluation or jail stay. So far from what I'm seeing, I'm agreeing with all of you on that. For the reasons not relevant here, the order was stayed until September 8th, when Fitzsimmons was released subject to the above conditions. Okay. At the hearing held that day, Fitzsimmons filed a document styling as medical notice containing a representation from counsel about Fitzsimmons' health issues. Now, here's where I'm going to agree with her, but there are other ways to monitor, so we'll get into that. Including that she had trouble breathing as a result of her injuries. At the conclusion of the hearing, Fitzsimmons requested permission to remove the required GPS device for a surgery. The following day, failed to submit any evidence establishing that she could not wear the device during surgery. The request was denied. All right, it depends on the type of surgery, but I'll be honest, if they're going to do surgery on her lungs when she's put under general anesthesia, there's no reason why they cannot remove the ankle monitor while the surgery is in progress and then put it back on once she gets recovery. Now, that said, the medical team and the staff in the hospital and their policies and procedures, they would have ways of dealing with that. But if the ankle monitor could potentially disrupt the machines and cause problems with them giving correct and accurate information, such as heart monitoring and all of that kind of stuff, then I could see why that they would want to have that removed for her safety. Otherwise, it can stay on. I've had them, depending on what the procedure was, I have had them leave my hearing aids in place, but they're not GPS monitoring stuff. So, on September 10th, filed a motion entitled Defendant's Emergency Motion for Immediate Relief from SCRAM. order which represented due to her injuries, it was physically impossible to comply with the scram requirement as performing the test caused for severe pain and dizziness. The motion attached affidavit to this effect that Fitzsimmons and her mother, Fitzsimmons and her mother. It also attached an email message from a probation officer noting that when taking the practice scram test, Fitzsimmons appeared to be in pain and struggled to complete the test. Okay, I'm going to pause here. If she had chest wounds to the point to where she physically does not have the ability to inhale deep enough, oh, that caused a cramp, and exhale long enough to get an accurate reading, then the way I would accept that is to have a physician with her, and while they did the test scram, with a physician present, and then that physician would observe her, put the pulse oximeter on her, put machines, whatever they need to do to monitor her, and that physician can deem it safe or unsafe for her to do. If a physician has done such and they have deemed this is not something that's safe for her to do at the time, then she shouldn't do it. But they do have these bracelets that you can put on put around I think it's your wrist, sometimes your ankle, that monitors your skin and your sweat. And if you've been drinking, it'll pick it up. So there's other ways to do this. It's not a black and white process, in my humblest of opinion. Let me go back to some of these comments. Here's a minute 20. Yep, I was reading them, and again, it seems like you and are still agreeing on the same page. Glad to see you here. Thank you for coming. Everybody, thank you so much for joining us. I do think if they were going to grant her release, they could accommodate her injuries. So on that small point, I disagree with the court's decision. Once again, her saying it and her attorney saying that she struggles and her mommy saying it, that's not enough. Now it does say right here, also in attendance, attach an email message from probation officer noting that she was taking the practice scam test. Fitzsimmons seemed to be in pain and struggled to complete it. Well, people can fake it too. Hence why I said medical staff should be able to ascertain. Now they have something. It's a little plastic device that we all hate, that the bubble goes up and down when you inhale and then exhale. If she cannot do that particular little exercise that you do to strengthen the lungs, which I guarantee you, she was given that. Anytime you have lung damage, problems with your lungs, like pneumonia, or you're in there for lung issues, whatever, you have that little device, and it is to exercise your lungs. It's a help. It's a rehab device. They could use that rehab device to determine where she was and whether or not she could or could not do this test. Because if you can't do that, you definitely can't do this test. What people don't realize is when you're blowing into this thing, you take a deep breath and you blow as hard as you can. And by the time you feel like you're going to turn blue, it's over. So it is not an easy thing. I mean, if you've got lung issues, this is very difficult. Now, a hearing was held on the next day in front of the same judge to address Fitzsimmons' motion. While Fitzsimmons' counsel described the request as a simple adjustment of terms, the hearing judge disagreed and observed that one of the reasons to ensure the safety of the community was for her to be alcohol-free. There are other ways. What is the name of the device that you wear around your wrist that will detect if you've been drinking alcohol? Thank you. Spirometer. Gotta know it all too well after my last surgery. Yep, amen. It's a scram bracelet. I was right. They do have it. Worn around the ankle or the wrist. It continually detects alcohol. Through the skin, it measures alcohol vapors and perspiration. It can detect drinking within 24/7, even in small amounts. It is used by the courts, probation, parole, child custody cases, blah, 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 blah. Important details. It does not require breath test. It cannot tell how much you drank, only that alcohol is present. Results are transmitted electronically through a monitor device. So, in my humble opinion, if she was shot in the chest, this could be a very logical and very viable problem for her. Then why didn't they just put a freaking bracelet on her? If it pops alcohol, then she has to go to the hospital. They draw her blood, and they can tell exactly what's going on. So, to me, I'm a little bit on the fence with this. So, let's keep reading. Amend her order, no medical. Okay, the judge expressed reservations at being asked to amend her order with no medical evidence to support the request. Moreover, the judge is hearing. I'm turning on my heater, guys. The judge at the hearing, the judge said that the probation officer email message was not evidence because it was hearsay, and that in any event, she gave it to zero weight. Nevertheless, the court took testimony from the probation officer who authored the message, and without objection from the Commonwealth, he testified to the substance of the message, stating that when Fitzsimmons performed the practice scram test, I'm going to zoom up, he observed her to be in pain. Fitzsimmons' counsel offered the message a second time, at which point the Commonwealth objected on the grounds that the probation officer had already testified to its substance, and the hearing judge excluded it. Fitzsimmons' counsel also reported to rely on the previously submitted medical notice to establish that Fitzsimmons had difficulty breathing as a result of her injuries. In the Fitzsimmons case, between the date of her injury and the date of her release, how many days was it? I don't know if I'll get the answer. I didn't word it well. Okay, general law cited, second part provides in relevant parts. It is the Kelsey Fitzsimmons. I need the date release from hospital and the date that she was reprimanded back into court after she was on supervised release. Okay. She was shot on June 30th of 2025. She spent 53 days in the hospital after being shot and was released September 8th under the conditions of house arrest. From injury, June 30th to the hospital release, a total of 70 days. So if you have a lung injury, that can be permanent. So we don't know. See, what I would love to hear right now would be from an actual doctor that treated her and could say, I would have subpoenaed a medical doctor and I would have them come in and explain as to potentially why this might be a difficult task for her to perform. And I think that is a reasonable thing. As to why her attorneys did not do that, I do not know. So that's something that I would want to know. Have a doctor come in and say, subpoena the doctor and say, okay, under the conditions of which, oh crap, under the conditions of which she has been released, she is still struggling or claims to be having this kind of What is your humble opinion? I guarantee you they would have no problems explaining or have any problems medically validating the problem or debunking it. Get the doctor in there. I don't understand why these lawyers, if you're going to file a motion like this, why in the hell would you not bring a doctor in? All it is a subpoena. This is true in many states. A lot of will let you try the ankle monitor or the breathalyzer. Both works. Well, that's her karate cat mom. You're probably right, but that doesn't mean if it was real He may not have thought about it too. I think that'd be stupid of him if he didn't. So the hearing under may be reopened by the judge at any time before trial or upon the motion of the Commonwealth or a person's detained if the judge finds that number one, the information exists that was not known at the time of the hearing, that there could be change in the circumstances, or two, that such information or the change in circumstances has a marital bearing on the issue of whether conditions of release that will reasonably assure the safety of other persons or community. Now, and the Fitzsimmons counsel argued that it would amount to torture and cruel and unusual punishment in violation of the Eighth Amendment of the United States Constitution to insist that Fitzsimmons remained subject to a scram testing. He contended that alternatives for alcohol testing existed. He suggested an appropriateness of urine testing, but also acknowledged that it might step on the court's other order for house arrest, because Fitzsimmons would have to go to a facility for that testing. Okay, pause. It won't step up on the court's order because urinalysis is a part of probation. Probation can go to the house and do it, or she can go to the probation because she can go to the probation. I have known probation officers who have picked up people and taken them in themselves for testing. I call bullshit on that. Oh crap. Hello, Java Queen. Thank you for joining me. I call BS on that. Right here. This right here. I call BS on this. Even. What? Oh, BS ate my fanny, scram her butt, and be done with it. So, in reality, personal knowledge from someone really close to me that was on pretrial services, which is like probation but before trial, who was on house arrest, who had to go through all that stuff. At any time they felt that there was an issue, they could have come into the home and made them do a test right there. They could pick them up and take them down to the probation office and make them do a test right there. Either way, they're in custody of the probation officer, so it does not step on the toes of the court. So that's crap. Right. Fitzsimmons counsel did not identify any other apart from the urine testing. Well, guess what? They all know that you have the ankle monitor. You can do all kinds of different things. Yes, music. I got my. Oh, cool. After a recess, the hearing judge concluded that the scram testing conditions were necessary to ensure the safety of the community. And based on the review of the material relied on by Fitzsimmons, including the testimony of the probation officer and counsel representations, the hearing judge concluded that Fitzsimmons could no longer comply with the requirement. Consequently, the hearing judge vacated her prior order releasing Simmons to pursuant of cited, and the order of Fitzsimmons held without bail on dangerous grounds and pursuant cited. The hearing judge issued written decision that the same day in which she noted Fitzsimmons' counsel failed to present any specific viable alternatives. Well, Your Honor, probation has those alternatives. You could have done it. You know about those alternatives. And this kind of feels like to me, and this is my own personal opinion, on one side of the coin, I can go devil's advocate. You were looking for a reason to fail her in. You gave her all these all these conditions, and if for any reason whatsoever she could not comply with those, for any reason you would pull her bond, just so you could preserve that you did legally what you felt. Come on, guys. On one side, I can sit there and say, oh, well, the judge just was looking for a reason. The other side, I can say, well, he had a choice. He could do it or not do it. Medically speaking, it truly is a medical situation, in my humble opinion. I should have brought a doctor in. That was a screw up on the defensive side, in my humble opinion. If I was her, I would be, and I'm telling you the truth, and I'm not lying, and I'm not, exasperating my situation to try to get out of doing something, then I would definitely bring in the doctor. Where's the doctor? Give me medical proof. Fitzsimmons moved for reconsideration, asking the hearing judge to reimpose the prior conditions of release with the urine test in place of the scram test. Okay, so right there, they did give an alternative. Right here, failed to present any specific valuable alternative. Well, okay, so now we're giving you a viable alternative. You want a viable alternative? Here it is, right there. And there's a lot of people on our probation in our county for pre-trial and post-trial probations that they have to call in every day. Their color is green or red or gold or blue or purple. And if your color is called, you have so much time to get into the testing site to get tested. So if they can do that for posts, they can do it for free. They can say, here we go. All right, let's see what they say. This time, didn't mean to do that. Oh, I can't do that, can I? Didn't mean to do that. By the way, those who are just joining us, I spilled coffee on my keyboard and my keyboard is dead. Fitzsimmons referred to a specific program whereby she reported that she could receive random urine testings at a location 10 minutes from where she was residing. Her motion attached an email message from the same probation officer sent to Fitzsimmons' counsel on September 10th, stating that the only alternative to scram testing would be testing with his vendor. The message noted that through this vendor's program, in a day, testing was required. Fitzsimmons would receive a same-day notice that she needed, and she would have to travel to one of the testing vendor sites to submit the test. The days after filing her motion for reconsideration, Fitzsimmons filed a supplemental exhibit and a letter from the doctor at the hospital where she had been admitted for treatment of her lead shooter related injuries. In the said letter, the doctor wrote that Fitzsimmons' injuries, which included a lead shot wound to the chest and rib fractures, can cause pain which may persist for several months and can also cause chronic pain that can be exacerbated by movements such as deep breathing. Okay, if this there's a letter from a physician, guys, I sat there and said, give me something from a physician. I said that, and there it is. But it's not under oath. Why are they avoiding the scram or other than possibly cost? I think that if someone would have said the ankle monitor for the scram for monitoring alcohol, maybe no one brought it up. Maybe no one thought of it. I don't know, but we're all thinking of it. But there's your doctor's excuse right there. September 16th, hearing judge denied the motion declining to hearing pursuant to cited. Otherwise, reconsidering her ruling. In her written decision, the hearing judge observed that the information submitted in support of the motion was known to Fitzsimmons at the time of September 11th hearing, pointing to the fact that the attached email message from the probation officer described the urine testing program at issue was sent to Fitzsimmons counsel the day before September 11th hearing. Moreover, hearing judge observed that the message described requested to employ this particular urine testing program, which was only alternative, would require Fitzsimmons to travel to one of the vendor sites for all testing. And the same day notice provided through this program would preclude the 48-hour notice of probation required for limited exemptions for home confinement. Okay, I'm going to call bullshit on this. If I had a dental appointment because I had a cavity, if I had to go to the doctor because I had a cold and I needed to see a doctor, non-life-threatening emergencies, no, they cannot deny you the right to access health care. That would require the 48-hour. Now, If it was a life-threatening situation and they needed to either be driven or gone by ambulance to an ER, they don't need a 48-hour notice. You pick up the phone, you call probation, your mother, your father, whomever. My daughter's found unconscious. We think she had a heart attack. EMS is now here. We are going to the hospital. It's a GPS. They can see where she is going. And on top of that, if you have to do a pop-up testing, which can be written into the order. I mean, this judge, I think, is being a little bit overly ridiculous, unless she just really wants to see this woman in confinement. I call BS on that. Average things such as what was explained in the conditions of release 48 hours, but she could modify it to the fact that if she got popped for a UA, it's what we call being popped for a UA, then she is to notify her probation officer when she leaves the home, calls when she arrives at the UA, she calls when she leaves the UA, and she calls when she arrives home. From personal experience for someone very close to me. This is what happened. That is how it's handled. But the judge, to me, I mean, and I'm not trying to be mean, I'm not against the judge, and I honestly think she needs to stay in jail. But on the devil's advocate side, I mean, this is easily done, and it happens every day with thousands of people, if not tens of thousands of people in the United States on probation. They have the same order. You can't go anywhere, do anything without a 48-hour notice unless it's X, Y, and Z. Going to get your UA done, you call when you leave, you call when you get there, you call when you leave there, you call when you get back home. Period. End of discussion. Period. It's not that difficult. Not that difficult. My son went and saw the Avatar fire. I want to go see it. Now I have to buy a keyboard. I can't afford it. Dag nabbit. October 2nd, 2025, Fitzsimmons petitioned a single justice of this court for extraordinary relief pursuant cited. In her petition, as she has done below, Fitzsimmons contested the Commonwealth's version of the events, but admitted that she took out a firearm during the June 30th encounter with police that she said raised it to the side of her head in a half-hearted attempt to inflict self-harm. The petition criticized as intemperate the behavior of the hearing judge at the September 11th hearing, and it asked for relief from order detaining Fitzsimmons. Yep, I can't afford to. Very much sucks. That's why super chats are so grateful. I have to keep the bills going. I have to pay the internet. I have to pay for now a new keyboard. I want to thank all of you. Let me take a moment here and say thank you to all of y'all for your love and support this year. Only because of you have I been able to do this, and I greatly, greatly appreciate you. And let's see if I can do this. And I need to thank all my mods. Let me see if I can do this without a keyboard. I know I created it. Where is it? Uh-oh. I'll have to find it. Dag nabbit, dag nabbit. I know I created it. I wonder why it's not. Oh, snap. Let's see if I can do it. Let me turn on my keyboard. Tell me you're not coming on now. Oh, man. Is it officially fried? Y'all, I think she's officially dead. I think she's officially dead. Yep, we're dead. 100% gone. Let me get this in the home. Let me try and get this. I doubt it's going to work. I think we are officially dead. This sucks. It sucks. It sucks. It sucks. I know I created you. I'm going to delete this one. Delete page. Share. Download. Load. Guys, after this, as soon as I'm done with this live, oh, there it is. I don't have to do this. No, I found it. Let me see if it's showing up. Wonderful. Now I can't find it and I can't type. Y'all, this is so disheartening. I am going to have to do it the old way. Doesn't have it. Share. Download. Download. It's so frustrating, y'all. Let's see if it comes up here. Why is it not showing up? That's not what I want. What file is, where's this located? It's not showing it. All right, guys, let me try one other way. I had something I want to say to my mods. It was very important. Very important. When you don't have a keyboard, never mind. Let me try it this way. I can't type. I can't name it. I can't do anything. Let me see where it shows up. It shows up in download. So why is it not showing up in this download? Oh, I wonder. All files. That helps. Okay. I don't want an M4. I want it. Here we go. Thank you so much, mods, for my graduation gift. I love them. They gave me a beautiful Highlander calendar. That blanket that says, "I'm not lazy, I'm just energy saving mode," is now covered in coffee and will be washed as soon as I leave the room. Every day is new beginnings. Take a breath and start again. That's today. And of course, that little glass that I drank out of the other day. Absolutely love it. Thank you so much, my mod. Thank you, thank you, thank you. Be blessed. Good morning, good afternoon, good evening, depending on who you are and where you are. Okay, back to this. The Commonwealth version of the events admitted that she took out the firearm. Okay, she went to self-harm, asked for relief of the order detaining Fitzsimmons. I keep wanting to call him Fitzsimmons. Specifically, it asked that the order be vacated and that the single justice addressed bail de novo and release Fitzsimmons on personal recognizance with only the condition of the stay away order. Issue is not on dangerous grounds pursuant, but instead pursuant to cited that the petition also requested that the hearing judge be recused from further proceedings in the courts in this court superior court. In support of the requested relief, Fitzsimmons argued to the single justice that the hearing judge erred in declining to employ an available common alternative method of alcohol testing, which was less restrictive alternative to the incarceration. The single justice denied the petition without a hearing, concluding that the hearing judge did not err or abuse her discretion. So basically, what they're saying here is she put an argument before a single justice or judge, that the hearing judge, the one who is that's assigned to her case, erred in declining to employ an available common alternative method of alcohol testing. The single judge, the one that she's appealing to about the one who is in charge of her case, denied the petition without a hearing. Yeah, that's going to piss some people off. Hello, Vanessa Joy. Hello, hello. Concluding that the hearing judge should not err or abuse her discretion, Fitzsimmons now appeals raised the same argument that she presented to the single justice, and asserting that the single justice was required to conduct a de novo review of the order returning Fitzsimmons to custody. So the decision, and when you see all these GLC 211, whatever that sign is, number 3, that is all, again, what I say, all cite. I will call those cites, okay? We reviewed the single justice denial of petition for clear error of law or abuse of discretion, and we must also consider the propriety of the Superior Court judge underlying bail order, including an order holding a defendant without bail pursuant to citation omitted. Campbell versus Commonwealth, blah, 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 blah. We begin by noting that the charge against Fitzsimmons, assault by means of dangerous weapon in violation of blah, blah, is a predicate offense for detention pursuing of blah, blah, blah. See Cruz versus Commonwealth, Mass, whatever, 24. Where the Commonwealth has properly moved pursuant to 58A for pretrial detention on dangerousness grounds. A hearing judge may order a pretrial detention only where he or she finds by clear and convincing evidence that no condition of release will reasonably assure the safety of any other person or the community. On the other hand, where a hearing judge determines that conditions of release will be reasonable, assure the appearance of a person as required and the safety of any other person and the community, he or she shall order pretrial release subjected to at least restrictive further conditions or combination of conditions that will do so. Fitzsimmons contends that the hearing judge found pursuant of 5A, 58A2, that the community's safety reasonably could be asserted through the imposition of certain conditions of relief, that the pursuant with the Fitzsimmons request for a urine test in place of the scram testing. The hearing judge was required to make that substitution because it was a less restrictive alternative to incarceration than nevertheless reasonably would assure the safety of the community. What do you think? Do you think that the testing through the scram testing and urine testing are equal? Do you think that one is better than the other? Do you think the request for the urine testing in place of the scram testing was a reasonable accommodation? Do you think the hearing judge got it wrong? Comment below. This is an open discussion. We conclude that the hearing judge did not abuse her discretion in denying the request and detaining Fitzsimmons. After the August 28 dangerous hearing, the hearing judge appropriately imposed conditions restricting Fitzsimmons' release. including the scram requirement. Well, yes, but there's a second scram requirement that would have been just as good as the first, and that's the ankle bracelet that monitors the alcohol through the sweat and gland, through the sweat of the skin. The evidence presented at that hearing described supra justified those conditions. Although Fitzsimmons argues that alcohol did not play a role in the June 30th indictment, the materials submitted by the Commonwealth at the August 28th hearing indicated that she struggled with aggression and alcohol abuse, and that she had been convicted of an offense apparently arising from intoxication and disruptive behavior in the past. My word, I inserted in the past, and that she was recently alleged to have become violent when drinking alcohol. The hearing judge properly considered these materials when imposing the conditions necessary to protect the safety of the community, conditions that included abstinence from alcohol monitored by scram testing. Well, one kind of scram testing, blowing in device. If you've been shot in the lung and broken ribs, it takes more than 30 days, boo. It can take a year for a chest wound, if not never fully healing, causing extreme discomfort and pain. And sometimes also the bigger point for me is not the discomfort, but can she exhale and consistently inhale and exhale at the force that's needed for the length that's needed to get an accurate reading? And that is, to me, what is the more pertinent question, which is not being addressed here, which is frustrating the hell out of me. Moreover, the hearing judge appropriately concluded that Fitzsimmons could no longer comply with the previous imposed conditions of scram testing. Fitzsimmons does not contest this finding and indeed has relied on her representation that compliance with scram testing was effectively impossible for her to do to her injuries. In sum, the hearing judge did not err or abuse her discretion in concluding that Fitzsimmons could not comply with the least restrictive conditions necessary to ensure the safety of the community. Fitzsimmons should be detained on pretrial for dangerousness. Now, I'm going to say something. I'll say it in a minute. How much more do we got? Okay, I'll say it at the end. June, don't let me forget. I have something to say about judges. Just saying. I do. We further conclude that the hearing judge did not abuse her discretion in denying Fitzsimmons' motion for reconsideration on the grounds the alternative to which Fitzsimmons pointed, that is urine testing, would not, and then there's a break, would not what? Fitzsimmons also asserted an error in conduct of the September 11th hearing. She contested the exclusion from the evidence an email message in which the probation officer described her observation of Simmons in pain during the practice scram test, but the probation officer testified on the point without objection from the Commonwealth. And then the hearing judge ultimately credited that testimony. The message was therefore cumulative of the testimony, and that the hearing judge did not err in excluding it. See, blah, 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 blah. Best source information. The testimony of blank persons who have personal knowledge. Citation omitted. In addition, Fitzsimmons contested that the hearing judge findings in her September 11th order that Fitzsimmons did not submit medical evidence, and that is true. Hearsay or the word of a probation officer is not, it cannot hold weight or replace that of an actual physical physician in court subpoenaed to testify as to her condition and why she cannot complete the test. Had she had that, I think she would have won. Fitzsimmons asserts that the medical notice described in supra was medical evidence, but this document contained only representation of Fitzsimmons' attorney and in any event. The hearing judge concluded that, consistent with the representation of Fitzsimmons, was unable to comply with the scram testing. In sum, Fitzsimmons' representation that she could not comply with the requirement, the hearing judge just so found it. So basically, You're not guaranteed. Let me see. This sounds like the judge wanted to close a real-time monitoring as possible. Yes. UA would alert immediately alcohol dangers. True. Since she cannot breathe, she needs to be detained. Skin scram may not be available in that jurisdiction. I would definitely agree with you. Why can I do that? I would agree with you on that. If they do not have the ability in that county to do the ankle bracelet scram test monitoring, then you're right. And UAs are not instantaneous. Before the single justice Fitzsimmons represented that. Okay, and here's the other thing. In these scrams, they're required to blow in them at certain times during every day. It's a daily monitoring. And they can also be called upon to do it at will. So you can test it at 8, noon, and 7 at night, 8 in the morning, noon, and 7 at night, for example. They can call you at midnight and say, we need you to go do a test. And you have to get up and you have to go log, and you have to go blow, you have to do all that in the home. So that is true. It is much stricter and a lot more control than a UA. By far, UA is by far a lot less controlled and a lot less frequently because you have to drive there, and it's a lot more cost effective. In a lot of ways, the UA is not going to be as good of a monitoring system. But if they had the bracelets, that would have been different. But do they? I don't know. Before the single justice Fitzsimmons represented, there were numerous alternative alcohol monitoring options available, but specified only 2 other parts from urine reasonably have assured the safety of the community because it would have interfered with the conditions of the home confinement. And that is up to the discretion of the judge. I have argued that she could call in and say, I'm leaving. She calls in, I'm there, I'm leaving calls in and says, I'm leaving the place, and calls in and says, I'm home. But that still means she's out in public. And that is what the judge was not wanting to have. Indeed, Fitzsimmons' counsel had acknowledged at the September 11th hearing that urine testing might step on the court's other orders for house arrest. Fitzsimmons' motion for reconsideration specified that the urine testing program she requested would require her to travel 10 minutes from her house for any test. Are they going to travel 3 times a day? That is where I believe the court has the right to say this is not acceptable if it's 3 times a day. If it's once a day, borderline. I'm playing both sides of the coin on this, y'all. Both sides of the coin I'm playing. In denying Fitzsimmons' motion for reconsideration, the hearing judge purportedly concluded that the community safety required minimalizing the number of times that Fitzsimmons is excused from the house arrest. And that right there is so freaking legit. I won't argue with that. The judge has a right, and that is very legit. Fitzsimmons also argued that the hearing judge violated the Title II of Americans with Disability Act. Well, not really, y'all. Now here's where I'm going to have a lot of argument. In denying her request to an alternative testing, which she classifies as a request for reasonable accommodation, already requires the imposition of Fitzsimmons' requested condition release, whenever it can reasonably assure that the defendant's appearance is the safety of the public. Fitzsimmons provides no citation for proposition that whereas here, the hearing judge acted within her discretion in concluding that the request alternative would not reasonably protect public safety. Title II nevertheless requires its imposition. No, it doesn't. Title II would nevertheless require its imposition. American Disability Act does not require the judiciary to take any action that would fundamentally alter the nature of its activities. Testing. Citation. Transdermal scram bracelets, which Fitzsimmons acknowledged are not currently available in Massachusetts. There you go. That's why they can't do it. They don't have them in Mass. All right. I want to talk about Title II of the ADA law, because let me tell you, they're using it wrong. I need the Title II of the ADA law. I am an ADA law specialist, so I'm going to give you this. public service, state and local governments. The Title II of the American Disability Act, ADA, prohibits disability-based discrimination by state and local government and any program service activities. Okay, courts and law enforcement, blah, 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 blah. Provides equal access and programs and services, reasonable modifications to policies and procedures, provide effective communication. All of that crap entitled to, it's not crap, all of the stuff entitled to has to do with, I'm a deaf person. I'm going to come from that angle. I'm in court. I ask for an interpreter because I'm not understanding the proceedings. They have to get me an interpreter under Title II. But I am qualified and deemed a disabled person. She is not. She is not under the Disabilities Act and all of that. She is not deemed a disabled person. She's not deemed disabled. It's a medical necessity, maybe a medical request, but she is not disabled. Now, had a physician declared her disabled because of the shot wound to her lungs, and it diminished her oxygen carbon monoxide exchange rate to the point that her blood ox is sustainably low and she has to be on oxygen, for example, in order to live, that's a disability. But at this point, she's not declared disabled. Therefore, the ADA is non-applicable. Period. So this whole ADA requirement pisses me off that you would throw the Title II and the Americans with Disability Act in here. Reasonable accommodation. That's if you are disabled. You are not disabled. A reasonable accommodation, if you're in prison and you're an amputee and you were required to have your prosthetic in order to walk, they can't take your prosthetic away and say it's a weapon. Now, if you use it as a weapon, then they could. But in general, that pisses me off. Fitzsimmons did not propose these alternatives during the September 11th hearing, that her motion for reconsideration was based specifically on the request for urine testing through the program described supra. Moreover, Fitzsimmons did not provide a single justice with a further detail regarding the letter of those two purported alternatives. We read Kelsey. Her fiance looks so happy and mixed together. Yeah. How many days was she at home? Not long. Not long. In the Kelsey Fitzsimmons case, how many days was she held on house arrest before being remanded back to jail? In any event, Fitzsimmons' representations in this respect run counter to the email message that she submitted to the hearing judge, and the single justice described the urine testing through the particular vendor at issue as only available alternative. The single justice therefore did not abuse her discretion in denying relief on the basis of those purported alternatives, because the record did not establish that they were reasonably and could assure the safety of the community. Just a few days, about 3 days, and that was it. So she was only in house arrest for 3 days. Last page, y'all. In addition, Fitzsimmons asserted that her return to custody pursuant to September 11th order was governed by blank, and the single justice correctly rejected this argument, observed that the hearing judge was authorized by Section 58A blank, cited to reconsider her order imposing the condition of relief, which was Fitzsimmons' motion had asked her to do so, and indeed the hearing judge ordered holding Fitzsimmons without bail expressly state that it was issued in pursuant of cited. Conclusion: for all the foregoing reasons, we conclude that the single justice did not err and abuse her discretion in denying the requested relief and pursuant as cited. Neither did the single justice error, abuse, in her discretion in declining to review the detention order de novo cited. Bam, thinking it is noted that Super Fitzsimmons was also requested that the hearing judge be removed from the case, but Fitzsimmons did not move for the judge recusal in the Superior Court, and she did not specifically develop a recusal argument with citations to legal authority before the single justice or before this court. Meaning they didn't deal with it. We note that the single justice also noted that nothing prevents Fitzsimmons from requesting in Superior Court that the matter of her pretrial detention for dangerousness be reopened if and when she can show that information exists that was not known at the time of the hearing. This is always a big key right here. Not known at the time of the hearing or therefore had been changed for circumstances. Such information or change in circumstances has a material bearing on the issue of whether there is conditions of relief that will reasonably assure safety of other persons and or the community. Bam! We did it, y'all. We got it done without a keyboard. Go figure. Go figure. Yeah, y'all, I'm without a keyboard. I spilled coffee and I killed a $300 keyboard. Yeah, I did. I killed a $300 keyboard. Let me pull it up and see what it's worth now. Dagnabbit, I can't. Shoot. Let me go on my phone. Let me see what Amazon has. Logitech. Oh no. Logitech G915 wireless keyboard. Logitech G915. Ooh, they've gone down. Still $200. God almighty. It does. They do have cases for them. So now I'm going to have to go to, we only have Office Max. I could try to go into San Antonio, but I don't know if I want to do that. Dagnabbit. All right, guys. So that is the end of that. I just fried my keyboard and it's no longer functionable. Hang it. So I cannot type anything back to you. But Blazy, last time was when she was in the house arrest for September 2025. She has no contact order for the court. Yeah. So guys, this is going to be an interesting case. It's going to be really interesting. And the other thing is also I have been working on, and I guess I'm going to have to, depending on where I have to go to get a keyboard, tonight or tomorrow. And I know we got a football game tonight, but I may have to dual dip on that. But tonight or tomorrow, I'm going to be going live because this is why I got to get a keyboard. We have been working on something. My fabulous June, did you put yourself up there or did I?
Ada, don't forget
my
about
fabulous mod June. Love
Ada,
you.
Don't forget
She's my
about the
research
judge.
queen. Was able to get her hands on the transcript and spent days, and I mean days. When I say days, I mean days. Spent days going through and finding all of the objections. I mean, all of the sidebars. And I have been going through all of those sidebars, giving commentary and breaking every single one of the sidebars down from the first Karen Reed trial. You're welcome, Bablazy. So we are going to go through the first trial objections because when the second trial comes out, we're going to do the same thing. Oh, the judge statement. Thank you, thank you, thank you, thank you. All right. I will say this, my own humble opinion. In my own humble opinion. When you appeal like she did on when you send an appeal to a higher court about a judge's behavior, i.e., you disagree with them, you think they're being biased, or you want to have them recused because you think they're being biased, whatever. In general, judges are going to side with judges. They are. It is super hard to get anything taken down like what this girl did. I think that this particular judge who reviewed this, that the appeal went to, did make the right decision. This was the correct appellate decision, in my humble opinion. I do not disagree with it. I think that it was upheld, and this judge that was being appealed, the judge that's hearing the case actually made the right decisions. But that said, when you have an appeal on an issue that involves a judge's decision such as this, or having them removed, it is brutally hard to win. You have to have screaming beyond all proof evidence that this judge did wrong. Because cops go for cops, judges take care of judges. I think that's 50% of it, and the other 50 is that they made the right decision. So, in my humble opinion, but I do believe that it just makes it even harder because judges do take care of judges. We do that. It's innate in human nature. So, with that, please leave your DNA. I'm getting ready to sign off because if I have to go to San Antonio, I can go and get back within 2-hour turnaround of drive time plus whatever it takes for me to shop. So I got to figure this out. I will see y'all later. We'll be continuing to cover the Fitzsimmons trial. We will cover their case. Anything else breaks down, we'll come in and hop in and read it, and we'll go over it and do everything. I hope you enjoyed my review. I actually read that for the first time through. I had no prior knowledge because I was working on the Karen Reed first trial transcripts and side-bys. So it was a very live and fluent reading for me as well. So I hope I was able to give you a little insight. Well, I will say what caught my attention more than anything was the ADA stuff, because that's where my heart is. And it pisses me off when they bring the ADA law into something they shouldn't be bringing the ADA law in. Anyway, that's just, y'all like my Christmas background. I can't believe this week is Christmas, and we then have New Year's coming up. So everybody, please enjoy time with your family. We will be hopping on either later tonight or tomorrow with the Karen Reed Trial 1 sidebar review. So come join us. And again, thank you so much, mods, for your love and support. We will see y'all later. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.